All right, peace and love, family. Today I'm gonna go over the court registry investment system, and I'm also gonna go over the breakdown of the trust. So I'm saying for everyone that definitely are watching this, pay real close attention, because like you always hear me say, if you listen long enough, you just might learn something. So the first thing we're gonna go over is going to be the court. Actually, we're gonna talk about the trust, and then we're gonna go into the court registry investment system. So let's go over there right now. All right, we're gonna talk about the trust. So let me cue this up. All right, man, here with the trust. So literally, I want you to pay attention, because if you pay attention, you won't miss this. All right, dealing with the trust, you got to understand there's three components with this trust. You have the grantor, trust, and beneficiary, and you're dealing with three aspects of law on this line. On the private trust. The private trust, you're always dealing with the republic, you're under common law, and you're dealing with the law of the land. See, in the public trust, which is the corporate United States, you're dealing with a democracy. And democracy is governed under admiralty maritime law and equity. It is also called the law of the sea. So you got the private trust up here, public trust down here. All right. Now, when you actually start this thing, you're going to be dealing as the grantor. And that means you're the living man / woman. And that's always going to be on the private side of that proponent. See how the grantor attaches itself to the trust, the grantor, the trust, and then the beneficiary. All right. The living man and woman is the grantor. Next, you have the trust that was actually created by the birth certificate, which is the birth certificate applications. See, the application from the birth certificate, which was mom, created a trust, which was created by the birth certificate of the application, which now there is a trustee, a private proponent that's in play here. See how this kind of lines up? Grantor is the living man. It was an application for a birth certificate by mom, which created the trust. Next, when they created that trust actually became a public trust. So they created a trust in the public. And the reason why this kind of went in that direction is because the birth certificate applied for was a security filed in the public, bringing the legal title into the public. See, the title to the name, the trust, was actually authenticated by this birth certificate. You see how that goes? You see how that lines up? Now, if I'm going too fast, pause this video, rewind it so you can catch what I just showed you. So you have the grantor, which is the living man and woman. You have the public trust that was created from the birth certificate, from the application from the mom. And see that, and the ownership of that, or in other words, the birth certificate is actually registered in the public. See, it was all done on the republic side, and then it crossed over into the democracy. See that? Now, in order for you to be able to utilize this in the private, this is where you're going to utilize the A for V and R for V. Accepted for value and return for value. Why? Because this birth certificate is being used. This trust that was actually created in the public is being used by the public for public welfare in a democracy. And in order for you to actually interact in commerce, you got to be utilizing that accepted for value, return for value, which brings legal title back into the private. See, when you operate as a creditor, you can actually utilize the A4V and R4V properly through this trust. Started out in a republic, it got converted into the democracy. Once you become a creditor, you can operate using an A4V, R4V, which is accepted for value and return for value, which brings the legal title back into the private, on the private trust. This is the private trust. So you actually can utilize this private trust proponent. Next, we have the conduit. So in other words, you got to have the living man who has taken control of that birth certificate in the public. So now he can operate as the trustee of that all capital lettered name, and he can utilize through HJR 192 the A4V proponent, which brings you to the beneficiary status, which is your estate, which is actually your alien property custodian. In other words, you're now the custodian over this trust that was created by the birth certificate. So you got the grantor, the trust, and beneficiary. See how these things all kind of went together? Next, I want you to understand what a constitution really is. Or better yet, what is the Constitution? Better yet, what is a constitution? A constitutor. Well, a constitutor is one who passes on his debt to a third party. The Constitution of the United States of America is an instrument that passes on the national debt to the states. The states became a surety for the national debts. This obligation was set in the Constitution and was not invoked until March 33 by President Franklin Delano Roosevelt, or what we know as FDR. See, how did the people become the sureties for the national government? Selling of one's birthright. In other words, a security interest possesses a legal and equitable title to the property described therein. The holder of that security instrument possesses the legal title to the property described therein. The application for the birth certificate is a security instrument describing the legal and equitable title to all goods held by the body through its name. Turning over the application for the birth certificate to the public transfer legal title to the goods, which is the estate. See, we go back to this, and so you can really understand the private trust. See, the actual grantor, which is the living, breathing, sentient soul, the living man and woman, was actually converted to a trust by application of the birth certificate. Now, when it was converted to a trust through the birth certificate, it wasn't for the living man's benefit, it was for the public's trust use. Why? Because they're in a democracy, they're under admiralty maritime law, which is equity, they're dealing with the law of the sea. They created this for their benefit. But when they did so, they had to give you an exemption, which allowed you, if you utilize A4V properly, you're able to literally gain your estate back as an alien property custodian. See, these individuals had to expatriate out of the United States, and that's your Secretary of State, the Attorney General, and then also the Secretary of Treasury. These are individuals that are all expatriated out of the United States. And for you notaries, you're under that same expatriation, Title 22 of the United States Code. Now, here are your players. See, when you're in this proponent, now these agencies are all part of the beneficiary proponent. See, when you're dealing with the Secretary of Treasury, you're dealing with the IRS, the Federal Reserve Bank, and the Depository Trust Company, which is the DTC. These are the things that are governing the republic. See, in other words, this is your office. This is what I keep telling you, notaries. This is part of your this is part of your office, the DTC, the Federal Reserve Bank, and the Internal Revenue Service. All that is VIA because you are now the estate alien property custodian operating through the Secretary of Treasurer's office in the Republic. Now, your estate, which is your alien property custodian, which is being regulated by the Secretary of Treasury, dealing with the DTC, Federal Reserve Bank, and the IRS, now you can actually utilize your, as from a benefit. So the beneficiary, you have a right to these things, making the state, bring the trust back to whole, as the grantor. The grantor, which is you, created the trust. Your mom executed that contract through the birth certificate. It put the trust on both sides of the line. Then in number 3, you're now dealing with the beneficiary side, which is now this is your estate, and you're acting as alien property custodian when you're operating under House Joint Resolution 192 and utilizing the Secretary of Treasurer and their 3 agencies. Now we're going to go a little further here. All right. Now we're going to be dealing with the commercial corporate trust. And this is what goes on in the public. See, when you got these guys working up here at the top in the private, this is what's happening in the public. See, the public Federal Reserve has a commercial corporate trust. And now they're operating with that public trustee, which is that trust. And then they're also controlling that straw man. So you have number one, the grantor, number two, the trustee, number three, which is your estate, which you're acting as the alien property custodian. Then it's being converted to use by the democracy under the public Federal Reserve, which is a commercial corporate trust. Then that commercial corporate trust, there are, when they have that agreement, the public trustee, they are operating as a public trustee in that capacity, and the beneficiary of all that is the straw man, which is number 6. And you should be able to follow what I'm laying out to you. We'll go a little further. Now, what part of the public trust did the Secretary of Treasury bail out? It wasn't you. So you got to look at this. See, the Secretary of Treasurer didn't bail out the living you. They bailed out the straw. Why? Because if you follow this line, follow the arrow, you'll see grantor, trust, beneficiary, Secretary of Treasurer went through the Federal Reserve Bank. The Federal Reserve Bank went to the public Federal Reserve. The public Federal Reserve dealt with the public trustee, and the public trustee bailed out the straw man. You see how that goes? Now watch this. Public trustees are your public officials. Your public trustees are your elected public officials, your appointed notaries. You fall into this. I told you, notary got one foot in the what? Private, and one foot in the public. Through the Secretary of Treasurer's office, you're actually a public trustee. And see, elected public officials, appointed public officials, lawyers, corporate officers, public trustees were trusts where trusts are recorded in the public. In other words, all this stuff is done through the courts. And see, the public Federal Reserve makes public grants for public trustees. And these elected public officials, appointed public officials, lawyers, corporate officers, public trustees, where the trusts are recorded in the public, they all are operating, and the straw man is the beneficiary. I'm going to keep going. Now, who are the public beneficiaries? Well, the public beneficiaries of the public trust are we the people. But there are no people in the democracy. These entities are fictions that represent you, though you are a slave. I'm going to say that again. The public beneficiaries, the beneficiaries of the public trust are we the people. But there are no people in the democracy. These entities are fictions that represent you as though you are a slave. They represent you as a slave. See, when you're dealing with their court system, they're treating you like a slave. They're treating you like a slave. And see, when you understand they have actually been utilizing their privatization of the birth certificate through the accepted for value and our return for value to the Secretary of Treasury. See, you got to bring your documents, you got to bring the public documents back to the private. You got to take all of these documents that you're dealing with, and you got to bring them back to the private. This is where your notary comes in. I keep stressing, your notary is the glue that holds all this together. Now, redeeming legal title. How does one do that? Well, one who issues a certificate of title holds legal title and is the creditor. One who holds a certificate of title and holds equitable title. One who holds a certificate of title holds equitable title and is a debtor. One who issues a certificate of title and holds legal title is a creditor. So if you hold legal title, you're a creditor. Let me be real clear. If you issue the certificate of title, you now hold legal title and you are the creditor. If you hold the certificate of title, you're holding equitable title and you are treated as a debtor. See, one who is utilizing A for V, which is accepted for value, and return for value, which is R for V, a certificate of title is the latest issuer of the certificate of title and regains legal title to the goods described therein. See, the certificate, I'm going to go back. See, the certificate, be sure I lost my place there. One who receives, all right, okay, you regain legal title to the goods that were described therein. See, the certificate of title is a pawn certificate or a claim check, and that's what's needed to reclaim legal title. Just put the banker's acceptances thereon and return it to the holder of the lien on the goods. In other words, when you're going to redeem legal title, you're going to start issuing certificates of title, which is going to put you in the creditor's seat. See, the one who holds that certificate of title is holding only equitable title, is treated like a debtor. See, the one who exercises accepted for value, return for value, you're dealing with a certificate of title, you're acting as the latest issuer of the certificate of title, and you regain legal title of the goods described therein. The certificate of title is a pawn certificate or a claim check needed to reclaim legal title. And all you need to do is just put the banker's acceptance on the instruments and return it to the holder of the lien on the goods. Now, this is what this whole layout is starting to look like. See, when you get this right, look at the line. You're going from the living man to the trust directly to the straw man. When you do this right, you're allowing the public Federal Reserve and the public trustee to then treat your estate as the beneficiary. See, the dual trusts work in harmony. See, the red are the roles of the private living man, and the blue are the roles played by the public government. In other words, this is the role of government. In the red, that's your role, grantor, trustee, straw man. The role of the public is public Fed Reserve, public trustee to your estate. Got it? You see this line? You see the flow. This is the ebb and flow you hear me talk about all the time. This is the ebb and flow that I talk about all the time. This is the ebb and flow. Go a little further. See, you got to now deal with what we call there's a third trust. There's a third trust in this scenario. And third trusts are the private international agencies. These are the referees. They are the babysitters. They are the babysitters between the public trust, the debtors, and the private trust, which are the creditors. See, there's a third trust in here. We're going to bring him up. See, when you're identifying the red blocks, let's be real clear. In the movie The Wizard of Oz, it identifies the role that one plays with respect to the red blocks. See, a commercial model is also identifies the role that one plays with respect to the red blocks. See, signatures are also dependent upon the roles of each red block. So in other words, you got to have those signatures. So you got to identify those red blocks that's in that layout. See, when you identify that, let's lay them out. So I'm going to lay it, the red blocks are going to be like the Wizard of Oz. So you got the lion, you got the Tin Man, and then you got the Scarecrow. See, in the Wizard of Oz, Dorothy is in the land of Oz, and that was represented by each of the three characters in the playing a role to get her remedy. The Tin Man was the creditor or the banker. And see, the Tin Man was the creditor and banker, and the Scarecrow was the debtor. See, the lion was the ambassador to control each of the other characters. See, the lion, who always say he didn't have no courage, we're dealing really with the Lion of Judah. Y'all already know that. Your Tin Man, he has no heart. he's rusted up. And then you got the scarecrow who doesn't have a brain. That's the straw man. Doesn't really know what's going on. Now, here's the commercial model. Now, the commercial model looks a little different because, see, the commercial model is going to show the grantor as the underwriter. It's going to show this particular trust as the surety. The surety is the trustee and the control, and it actually is in control of the private creditor. And then you're going to also have, at the end, the principal. The principal is the owner of the goods that's belonging to the public debtor. That's the straw man, the beneficiary. See, in the commercial model, we have been operating most of our lives as the principal. We need to operate as the surety. We have always been the underwriter. If we act as the principal, the currency moves from the DTC to the corporations. If we act as the surety, the currency moves from the DTC to the people. See how that works? See, when you're putting the signatures, that means you're dealing as the authorized representative. See, when you're dealing with these signatures, number one, the living man and woman signs the name, and with the word by in front of the signature, that means you're dealing, as a surety, and the surety signs his name with a clean signature. Number three, we do not play the role of the principal anymore. We sign as the what? Authorized representative. You see how that works? You see how that looks? And you see how this thing is really starting to make sense to you. Hopefully that made sense to you, and that kind of got you to where you're at. Now, I want you to pay attention, because in this next set of slides, I'm going to reveal to you something that's going to be very, very, very helpful. This next set of slides is going to bring up exactly what it is and what it isn't. What that is we're going to be talking about the CRIS. Now, when I talk about the CRIS, I have to make sure that everybody is on point. Why? Because when I talk about the CRIS, I have a tendency to go into a lot of things. And see, we're going to talk about the registry of the court. The CRIS stands for the Court Registry Investment System. We're going to be talking about the registry of the court. And this was presented by an actual official of Wilson County District Clerk. So I'm going to break this down to you. Now, this is right here is going to be the procedure on how you get liquidity through the court using the CRIS. We're going to deal with the registry of the court. See, each district and the court, each district and county clerk must maintain a bank account to receive money tendered into the court's registry. All funds must be deposited if they are not to be held for more than 3 days. See, the clerk should keep a record of all funds tendered into the court's registry, which includes, number one, the cause number, number two, the style of the case, and number three, the instructions regarding the investment or disbursement of the funds, and then number four, an accounting of all withdrawals and deposits. See, there's different types of registry funds, and I want you to pay real close attention to the individuals, to the different types of registry funds. These are the type of registry funds that you can access through the Court Registry Investment System. Number one, you can access the funds of minors or incapacitated persons. You can access the funds of minors or incapacitated persons. Number two, you can access funds tendered into an interpleader action. A lot of you may say, well, what is an interpleader action? I've heard of that before, Bazell, but I'm not sure what an interpleader action is. An interpleader action. You want to know what an interpleader action is? Well, an interpleader action, when you're acting as an interpleader, it's a procedural device used in a civil action whereby a defendant brings into a lawsuit a third party who is not already a party to the action, but may ultimately be liable for the plaintiff's claim against the defendant. So when you bring an interpleader action, you're bringing someone into this particular civil action. So you can technically, if you're following what I'm putting down, if you're following how all this stuff goes, then you're going to realize that there are a lot of things you can do when you're dealing with this whole little layout here. But I stress the fact that you can access the funds tendered into an interpleader action. In other words, if there's going to be an anticipated civil action, you can access those type of registry funds. Now, what's the other type of funds? Well, funds that are paid in satisfaction of a judgment. So when you get a default judgment, because the case has been monetized, there are funds that are attached to what we call the DOF. These registry funds are considered disputed ownership funds. And I'm giving you multiple ways on how they can be accessed. They can be accessed, for the satisfaction, or to assist in paying of the satisfaction of a judgment. So if you got a UCC on file and you're actually moving to satisfy judgment, you can now utilize these funds held on ledger. Also, you can actually deal with child support funds that are held for more than 3 days. You can also deal with cash bonds. A lot of folks get these cash bonds, like all these demonstrators who got arrested, this, that, and the other. They have those cash bonds, or they can be utilized. Also, you can have cash bail bonds. So you go through a bail bond company, then you got the cash bond that's done directly with the clerk. Either way, these type of registry funds are accessible. You also have funds that are in an eminent domain case. So let's talk about eminent domain. What is eminent domain? Eminent domain. Eminent domain. Let me give you the definition of eminent domain. See, eminent domain is the right of a government or its agent to expropriate the private property for public use. So you can actually take something from the private and use it for public use with payment of compensation. In other words, there's eminent domain refers to the power of government to take private property and convert it into its public use. The Fifth Amendment provides that the government may only exercise its power if they provide just compensation to the property owners. So eminent domain is also, they intend on taking something from somebody in the private for public use, and the Fifth Amendment allows them to do that if just compensation has been offered or issued. And I'm going to go back to this, shortly, but I'm going to show you how all this stuff rocks in. There's also another type, and these are any other funds tendered into the clerk for deposit into the registry of the court. So when you do promissory notes, bills of exchanges, all of those funds that are tendered to the clerk for deposit into the court, the registry of the clerks. So remember, every case that's brought is actually being what? Deposited. And there's monetary value in these cases. That's why it's called a disputed ownership fund, and you are allowed to utilize those funds if you are in this particular segment or dealing with the court registered investment system utilizing a civil law notary. We're going to talk about the registry court a little bit deeper. Let's give you some references for the following statutes. This is references information that you're going to need to know. You're going to need to know Chapter 142 of the Property Code for minor funds. That's Chapter 142 of Property Code for minor funds. You also need to see Section 31.008 of the Civil Practice and Remedy Code, which deals with the payment of judgments. You also want to go to Article 17.02 of the Code of Criminal Procedures dealing with bail bonds. And last but not least, you want to deal with Chapter 72 through 76 of Property Code dealing with escheat and unclaimed property. That's escheat and unclaimed property. Let's talk about custodialship, for example. See, a clerk shall act only in a custodial capacity in relationship to the registry of funds, a special account, or a separate account. In other words, the clerk can't treat these funds like it's their funds. They're just a custodian over it. So it's your job to provide the proper paperwork so business can be conducted. See, a clerk is not the trustee for the beneficial owner and does not assume the duties and obligations or liabilities of the trustee for the beneficial owners. And that can be found on the LGC 117.0521. Let's talk about the management of the registry funds. See, the clerk has two options when deciding on the type of registry to open. Yes, I told you the clerk opens these accounts. They can open an interest-bearing account. This registry account may earn interest. They can also open a non-interest-bearing account, which means the registry account may not earn interest. See, in an interest-bearing account, if the clerk elects to have a registry account earn interest, the clerk must do the following no later than 30 days. On the 30th day, no later than the 30th day before the date of the county gives notice that the county will accept applications to the depository. What depository we're talking about? The Federal Reserve Bank. So the clerk is actually opening an interest or non-interest bearing account with the Federal Reserve. See, making a written request to the Commissioner's Court that the contract includes a provision that funds in a special account in the clerk's name earn interest. B, the application of a bank that seeks to become the county's depository. In other words, there is a county bank, there's a local bank that becomes the county depository to the Federal Reserve, and they must be accompanied by a certified or cashier's check for the amount equal to 1/2 of 1% of the average daily balance of the registry funds held by the clerk during the preceding calendar year. The clerk must calculate this amount and include the figure to the Commissioner Court requesting that the registry account earn interest. This particular one is why I stress accounting. I keep telling everybody when you're dealing with current expected credit losses in the CAF reports, it's all accounting. I'm giving you the smoking gun because see, when the clerks do the application for the bank, they're performing an action in accounting, and they're actually I talk about this in different investments. They're actually doing an accounting maneuver, and they're operating this particular account as a zero balanced account. What do I mean? You only need to have in this account 1/2 of 1% of the average daily balance in order for them to utilize every other case calculation. I told you, if you're dealing with revenue, you'll learn that you can spend more than what you take in, because they're only required to bring forth a cashier's check equal to 1/2 of 1% of the average daily balance. See, the clerk must calculate this, which means she's doing accounting, she's doing bookkeeping, to include the figure to the Commissioner's Court. See, the county Commissioner's Court is actually what's making the request that it actually is holding the account. The clerk is just serving as the intermediary. Now we're going to talk about interest-bearing account. Now, if the clerk elects to have the registry account earn interest, see, then the registry account or you must be actually dealing with a separate account that earn interest. The clerk must keep a record of the amount of interest earned and the amount of each case. So she's got to keep a running tally of how much they're earning, how much the case is earning. Listen to this. This case is earning money while it's on the books. See, the clerk shall pay, listen to this, I told you the clerk got a checkbook. The clerk shall pay 10% of any interest earned to the general fund of the county to compensate the county for the accounting and administrative expense of maintaining the accounts. In other words, the clerk pays a 10% interest on the general fund, the disputed ownership fund. That's why it's called a disputed ownership fund, a DOF fund. It's a DOF fund that they're utilizing accounting all behind the scenes, and you have access to the Federal Reserve the exact same way. Now let's talk about a non-interest bearing account. That's used to compensate the county for the accounting and administrative expenses incurred in handling the registered funds. They have not earned interest yet. See, the clerk shall at any time of withdrawal deduct from the amount of the withdrawal a fee in the amount of 5% of the withdrawal, but not to exceed $50. Wow. So the clerk shall at the time of withdrawal deduct from the amount of the withdrawal a fee in the amount of 5% of the withdrawal, but not to exceed 50. See, withdrawals of funds generated from a case arising under the family code are exempt from the fee deduction. So if it's a family case like child support, they're exempt from it. Now let's talk about the investment of the funds. I told you it's called a court registry investment system. It's a system. It's a system. And I'm finna nail you in the cross right here. This investment of funds, the clerk shall transfer any registered funds into the separate account only when it directed to do so by written order of the court of proper jurisdiction, or when the clerk is required under probate code 887. Probate code 887, which is the investment of funds, and you got to do it as follows. See, number one, in the financial institution doing business in the state that is insured by the FDIC insurance. So in other words, the clerk shall transfer any registered funds into a separate account only when directed to do so by a written order of the court of proper jurisdiction, or the court is required, or when the clerk is required under probate. So in other words, if you do your administrative process properly, you are able to you can use these funds to make investments. And I'm going to give you the layout. Number one, you can make these investments into a financial institution doing business in the state that is insured by FDIC. You can also make an investment into United States Treasury bills. You can also, an eligible investment pool that meets the requirements under sections 2256 mortgage-backed securities. You can use it. You can actually, under this particular requirement, 2256.016 and 2256.017 and 2256.019 governmental code. In other words, you can utilize it to invest in mortgage-backed securities. Number four, a no-load money market mutual fund if the fund is A, regulated by the Securities and Exchange Commissions, B, has a dollar-weighted average stated maturity date of 90 days or fewer, and C, includes in its investment objectives the maintenance of a stable net asset value of $1 for each share, and D, a structured settlement account. In other words, you can direct the funds from the disputed ownership fund into these investments, which can actually be pointed to a structured settlement account. Now let's talk about how it comes out. This is the fun part. This is the fun part. This is how the revenue comes out of the court. It come out of the court through what we call a disbursement of registered funds. And you got to do this now, unless otherwise provided by the statutes or rules of registered funds, which are to be distributed only by court order. So, notaries, if you're able to acclimate a court order, you can draw these funds out of the court. Under court order, you can get this done out of the court. When we do the tribunals, it's a court order. See, when an order is received, the clerk will disperse the funds to the proper party accordingly, less the administrative fees. In other words, when they got a court order, the clerk goes to work. Now, let's talk about structured settlement payments. See, in a suit in which the minor or the incapacitated person who has no legal guardian is represented by a next friend or an appointed guardian, an ad litem, the court, or on a motion from a parties which may provide for the structured settlement that, number one, provides for periodic payments and is funded by an obligation guaranteed by the United States government and has an annuity contract that meets the requirements under section 142009. See, the persons obligated to fund the structured settlement shall provide to the court, number one, a copy of the instrument that provides funding for the structured settlement, or an affidavit from an independent financial consultant that specializes in the present value of the structured settlement and the method by which the value is calculated. In other words, if you're there under CECL compliance with an affidavit, you can point this to a structured settlement. I'll go a little further. A structured settlement provided for under the section is solely for the benefit of the beneficiary of the structured settlement and is not subject to the interest payment and calculations contained in section 117.054 under the local government code. Now we get to escheat funds. Escheat funds. Now, what are escheat funds? Well, personal property is assumed abandoned if dormant for longer than a period of 3 years. Those UCCs, let's be real clear. I hear everybody talk about these 1099 OIDs. These 1099 OIDs, you're dealing with escheat funds. Why? Because most 1099 OIDs are usually 36 months old or older. So escheat funds are the equivalent of what you put on a 1099 OID. Please remember that, because we're going to come back to that. See, these are any funds that are deposited under this chapter except cash bail bonds that are presumed abandoned under chapter 72, 73, or 75 of the property code and exceed $100 shall be reported and delivered by the county or district court to the comptroller without further action by any court. In other words, if you got a 1099 OID, that's all you need, and it's referred to the district court or the comptroller. See, dormancy periods is 3 years for all property types except for wages, which are for 1 year. So 1 year for wages, all other properties if it's dormant for 3 years. See, the escheat funds goes to each holder who on June 30th, bling, 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 June 30th, bling, 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 June 30th holds proper subject to this chapter shall file a report on the property on or before the following November 1st. In order for you to claim these escheat funds, you got to do it on June 30th. June 30th. What's today's date? What is today's date, family? Today's date is June 23rd. 7 more days. June 30th. June 30th. They hold the property proper subject. In other words, they hold proper subject to this chapter shall file a report of the property on or before the following November 1st. See, each report is filed with the treasurer of the holder. All should be done to notify the owner of the funds you are holding, and you have a record to keep of the last known address, or even though the mail may have been returned. Did you catch that? They purposely send these notices where the people are no longer located in order for them to justify them keeping these escheat funds and utilizing them. I told you how powerful the mail is. Now we're going to go to escheat funds. Here's the recommendations. Now remember, I'm giving you the playbook of how to move these funds through the CRIS. Here's the recommendation. On or around June 30th of each year, review your accounts and identify funds that meet the 3rd year dormancy period. Notify the property owners that the funds and the properties that are being held are kept, and keep all documentation of your efforts to notify the owners on or before November 1st. And you can complete the required forms and submit to the comptroller. See, All of this stuff that was done with the birth certificate and everything is all done with the comptroller of the court. And I've been telling people for years how this stuff can be done. Now, I reserve this training that I'm going in for notaries, agents, and trustees. Now we're going to talk about the excess funds. Because see, there's extra funds. See, the sale of property for delinquent taxes may generate excess funds over and above the judgment. These funds are turned over to the clerk issuing the order of the sale to be placed in the registry and dispersed accordingly to the law or as ordered by the court. The tax code requires that the clerk send out notices to the former owners of the property that exceed funds have been paid into the court registry. But how do they get around that? They send it to your last known address. The address you ain't no longer that. They send it there, it comes back returned. It is what it is. They keep it moving. Now, watch this. The retention period for these funds is 2 years. If the amount of excess proceeds is more than $25, the clerk is required to send out notices before the 31st day after the date of the proceeds are received by the clerk. So let me give you a scenario. For every court case that you actually dealt with where there was a bond and this, that, and the other that was done, and you did not receive notice by the clerk, you left money on the table and you have not filed your 1099 OIDs to collect it. See, the notices are sent certified mail and return recipient requesting the former owner of the property at the last known address according to the records of the court and any other sources reasonably available. See, regardless of the amount of excess proceeds, the clerk is to keep the funds in the registry of the court for a period of 2 years. They got to keep those funds on the book for 2 years. When you do this process correctly, the clerk has a checkbook. Checkmate. Here's the claim for excessive proceeds. A person, including a taxing unit, may file a petition setting forth a claim to the excess proceeds from the tax sale. A petitioner must be filed within 2 years from the date of the sale. The petitioner does not have to be filed as a new suit. The petitioner can be filed in the underlying tax cause. Interest and costs are not allowed under this section. See, the fees charged by an attorney to obtain excess proceeds for an owner may not be greater than 25% of the amount or $1,000, whichever is less. See, a person who is not an attorney may not charge a fee to obtain excess proceeds from an owner. See, in some instances, the judgment debtor may wish to clear his or her credit or title to property and must pay a judgment to accomplish this. I hope you don't understand. This is the payment of unclaimed judgments. See, in some instances, the judgment debtors may wish to clear up his or her credit or title to property and must pay a judgment to accomplish this. If you want to pay a judgment, you can use lawful legal money. You can write a bill of exchange to the court to pay the judgment. Let me say this again. I am going to, this is the part where I get really excited. I get really, really excited because if you've been listening to what I've been putting down, you can utilize a bill of exchange. You can utilize a bill of exchange to pay a judgment. So if you owe a judgment, use a bill of exchange. And if you're trying to collect the judgment, utilize the CRIS. A judgment debtor is allowed to pay the court that rendered the judgment, the amount under the judgment, which is owed to the judgment creditor, whose location is unknown, and the judgment debtor, if the judgment debtor complies with subsection B of the code, the payment must be made without offset or reduction. The judgment debtor shall prepare a recordable release of the judgment, and the judge or clerk shall execute the release of the judgment on behalf of the creditor and issue the release to the debtor. See, the payment of the unclaimed judgment, you do this, before being entitled to pay a judgment to the court, the judgment debtor must send a letter notifying the judgment creditor and judgment of the judgment by registered or certified mail. That one, judgment creditor's last known address appearing on the judgment creditor's pleading and other court records, if different from the last known address of judgment debtor's last attorney as shown on pleading, and the address of the judgment creditor's last attorney as shown in the records of the state bar, and you're dealing with Texas, if that address is different from the pleading. See, once the funds are placed in the registry of the court, the clerk will hold the funds in an interest-bearing account. The clerk must pay the funds and any interest earned to the judgment creditor of the successors, to the rights of the judgment creditor. The clerk may presume the funds are payable to the judgment creditor unless furnished with written assignment of the judgment by the court. And this is the actual Senate bill where all this is administered. And that is Senate Bill 1589 in Texas. So what you ought to do in your territory is look up the Senate bill that directly ties you in to this proponent. Here's a quick reminder. The property report must include, if known by the holder, the name, social security number, driver's license number, state identification number, email, each person who. Now again, I'm just going to roll up the screen so you can see all the stuff you got to give to the comptroller. These are all the things you got to give to the comptroller. See, Texas, if you ain't figured it out, is no longer a state. It's actually a republic. That's why when you do the UCCs a certain type way, you can take them over to Texas and get her done. Family, I hope this information was inspiring. I hope this information was enlightening. I hope this information has allowed you to really understand what it is that you must do. Because see, they say ignorance of it is no excuse. I say if you keep listening, you just might learn something. Peace and love. I got more exclusive content to go.